Thank you all for joining us today. My name is Stephen Cooper, Marketing Manager at DriverCheck, and I will be your host today and Q&A moderator for today's webinar entitled U.S. DOT Drug and Alcohol Testing Compliance. Thanks again for joining us. The next hour or so will be a practical overview of the U.S. DOT Drug and Alcohol Testing Compliance for FMCSA-regulated employers and cross-border carriers. We'll cover what DOT compliance means in practice, including testing types and frequencies, supervisor training requirements, random testing rules, and employer and employee responsibilities, and much more. We do have a lot to get to, but before we start, I'm going to give you a quick little spiel about DriverCheck for those of you who might be new. DriverCheck, sorry, just my script here. DriverCheck is Canada's fitness for duty expert committed to safety of your staff and workplace. Founded in 1996, DriverCheck is the leading provider of workplace medical testing assessments across industries like oil and gas, manufacturing, mining, aviation, and of course, trucking and transportation. From pre-employment and random testing to SAP and clearinghouse services, we conduct hundreds of thousands of tests each year. What really sets our approach apart, though, is how we support the entire employee lifecycle. You'll see this on your screen here in their hire to retire graphic, which visualizes how DriverCheck supports organizations at every stage of employment to deliver the right occupational health programs and testing at the right time. The goal really is simple: to build a healthier and safer world. And as you can see, it's at the center of everything we do. Also, just a quick mention that this year we're celebrating our 30th anniversary. We're very excited about that. So for those of you that are clients of ours, we definitely want to thank you for your continued partnership and trust and for helping us reach this momentous milestone. Thank you, thank you, thank you. Okay, so that's a very little about DriverCheck. Before I introduce our speaker, just some housekeeping rules that I'm sure everyone's familiar with by now. This session will be recorded and will be available on drivercheck.ca in a week or so. So if you miss some parts and want to go back to it, you'll be able to. Your audio and video is turned off by default. There will be a short Q&A at the end. You can submit your questions while a presenter is speaking via the Q&A function feature at the bottom of your screen. I'll be managing the Q&A at the end of our show here. Also, we will be sending out a quick survey to send to all of you at the end of the session. We love your feedback so we can continue to improve our webinars and present topics that you guys are all interested in. Okay, so today we are proud to have Brandon Kearse with us. Brandon is a privacy compliance coordinator with DriverCheck's risk management team, where he supports clients in navigating regulatory compliance, privacy obligations, and risk considerations related to workplace testing programs. His work includes advising, of course, on U.S. Department of Transportation, DOT, drug and alcohol testing regulations. Brandon brings a practical risk-based perspective to complex regulatory topics and works to ensure client programs remain compliant, defensible, and aligned with industry best practices. So that's now my job done. I'm going to introduce you to and pass it over to the very capable Brandon. Take it away.
Yeah, thank you for that introduction, Stephen. I really appreciate it. Hello, everyone. As mentioned, my name is Brandon Kearse, and I'm the Privacy and Compliance Coordinator here at DriverCheck. And my role involves ensuring that your drug and alcohol testing programs meet all regulatory requirements while safeguarding sensitive information and maintaining compliance standards. And today's session is focused on a topic that is absolutely critical for everyone operating in the transportation industry, and that's the U.S. Department of Transportation's drug and alcohol testing regulations. And these regulations aren't just about ticking boxes. They're about protecting lives and reducing risk and ensuring that your business operates within U.S. federal standards. And so why is that important? Well, it's important because transportation is one of the most safety-sensitive industries in the world. And every day, millions of people rely on commercial drivers to transport goods and passengers safely. And a single lapse of judgment caused by substance use can cause catastrophic consequences like fatalities, injuries, property damage, and reputational harm. And that's why the US DOT has established strict regulations to prevent impaired individuals from performing safety sensitive duties. And our goal today is twofold. Okay. So, first, I want to give you a clear understanding of what the DOT regulations require. And then the second is to show you how DriverCheck can support you in meeting these requirements effectively and efficiently. And compliance isn't about just avoiding penalties, all right? It's about creating a culture of safety and accountability. So before we get into details, I just want to make a note that there is a variety of attendees joining us on this webinar today. Everyone from new companies, new startups, and just getting out there into the field, to the opposite end of seasoned veterans with decades of experience. So for those of you that are new to drug and alcohol testing, this webinar is going to be very insightful and teach you a lot. And then for those of you who have been around for a while, I do have some new information regarding drug testing that I'm going to cover a little bit later in my presentation. So now with that, let's take a look at what we're going to cover today. So I'm going to start with the basics. What is the DOT? What does it stand for? Then I'm going to move into more specifics with compliance, including supervisor training requirements and how often drug tests are conducted under DOT rules. And then I'm also going to talk about what it means to be DOT compliant, focusing specifically on drug and alcohol testing regulations. And then from there, we're going to explore the clearinghouse, the FMCSA clearinghouse. Well, what is it? Why is it mandatory? And who needs to register? And then we're also going to discuss random testing requirements, the role of substance abuse professionals, and the return to duty process. And then finally, I'm going to review what substances the DOT tests for, which controlled substances. And then we're going to wrap up with how DriverCheck can help you manage all these requirements. And then by the end of the session, I'm hoping you have a clear roadmap of the practical steps you can take to protect your business and your employees. I also want to mention that during this webinar, I'm going to be focusing on companies that are regulated specifically by the Federal Motor Carrier Safety Administration, also known as the FMCSA, and that generally oversees, trucking and motor coach carriers, sometimes limousines that operate across the U.S. border as well as interstate within the United States. And the FMCSA is a specific administration within the DOT. And during this webinar, I'm going to encourage you to take notes. And then, of course, like Stephen said, you can ask your questions in the Q&A that's provided in this webinar. So let's begin. So we're going to start off, what does DOT stand for? Well, it stands for the United States Department of Transportation. It's a U.S. federal cabinet department that oversees all aspects of transportation, including safety within the United States. And when we talk about the DOT in the context of drug and alcohol testing, we're referring to regulations that apply to safety-sensitive positions, roles where impairment could lead to serious accidents or fatalities. And these regulations are enforced by the various administrations within the U.S. DOT, such as the FMCSA for commercial drivers. But then you have other administrations like the FFA that oversees aviation and pilots. You also have railway and transit. So the DOT oversees a broad range of different transportation modes. But for the purposes of this webinar, I'm focusing strictly on FMCSA because the majority of you are governed by the FMCSA regulations specifically. So understanding what DOT stands for is the foundation of compliance. And DOT really isn't just an acronym, okay? It's a set of rules designed to protect lives and ensure transportation systems operate safely. So the DOT plays a critical role in ensuring the safety and efficiency of transportation systems. And its mission is broad, okay, but at its core, at the DOT's core, it exists to protect lives and maintain the integrity of the U.S. transportation system. And this includes highways, railways, aviation, maritime operations, and public transit. And when we talk about DOT in the context of today's discussion, we're focusing on drug and alcohol testing, okay? And why is this necessary? Well, like I said earlier, transportation industry, an impaired driver can cause a serious accident and cause catastrophic damage, or potentially injuring themselves, killing them, maybe even killing themselves, as well as injuring the general public. That's the importance of it. Now let's take a closer look at what the DOT drug and alcohol testing program actually means for your business and why it's so critical to get it right. So first and foremost, participation in a DOT drug and alcohol testing program is not optional for those businesses and employees who are regulated by the Department of Transportation, especially those within safety sensitive positions such as commercial drivers. So if you operate a commercial motor vehicle within the United States, or if your drivers happen to cross the border, the US-Canada border in a commercial capacity, you're required by US federal law to comply with these regulations. And these rules are laid out under US federal law, specifically what's called Title 49 CFR Part 40 of the US Federal Code. And it's really the cornerstone of all DOT drug and alcohol testing. So what does compliance actually look like in practice? That's probably what you're asking yourself. What it means is that every safety sensitive employee, such as your commercial drivers, whose role could impact public safety, have to be enrolled in a comprehensive testing program that complies with the regulations. And this program has to cover several types of testing, okay? You have to do pre-employment testing, random, post-accident, reasonable suspicion, return to duty, and follow-up testing. And each type of testing serves a specific purpose in preventing substance use from jeopardizing safety. And the overarching goal of a DOT testing program is simple but powerful, and it's to prevent accidents caused by substance use, including alcohol misuse. And the DOT recognizes that transportation is a high-risk industry, okay? And that's why the regulations are so strict and why enforcement is robust. So as your compliance partner, DriverCheck is here to help support you in every aspect of your program. We're here to help you navigate the complexities of Part 40 of the U.S. regulations and provide you with the resources you need to train and report on your program. And I encourage you to think about your current testing program. Are all of your regulated employees enrolled in that testing program? Are you testing in accordance with the procedures of the DOT regulations? And do you have clear policies in place for handling violations and ensuring return to duty compliance? So what I want to focus on next is DOT supervisor training. Supervisor training is often overlooked, but it really is one of the most critical components of compliance. DOT regulations require that your supervisors who oversee safety sensitive positions, such as commercial drivers, complete training on recognizing the signs and symptoms of drug and alcohol misuse. And while this is only a one-time requirement for a supervisor under the more specific FMCSA regulations, it is essential and it is necessary. So the supervisor training has to include 60 minutes on the signs of drug use and an additional 60 minutes on the signs of alcohol misuse. And so why is supervisor training so important? Well, it's important not only because it's a regulatory requirement, but more importantly, supervisors are your first line of defense. They're the ones who are going to interact with your drivers on a daily basis. And if they don't know what impairment looks like, they can't act on it when it matters most. So here's a relevant scenario for you. So imagine you have a driver that shows up for work smelling of alcohol. That driver then gets behind the wheel of a commercial vehicle and has an accident. Well, if your supervisor hadn't been trained, they probably are going to ignore that situation and assume it's harmless. And now, because there's an accident involving that driver, and it was known to the company that there was something going on with the smell of alcohol on that individual, the liability is going to fall on the company, not just for the accident, but for failing to act on the signs of alcohol misuse. And supervisor training helps to prevent such a scenario from occurring. It's also important to remember that liability doesn't stop with the company, okay? Drivers themselves can face serious consequences, including the loss of their livelihood and potential legal exposure when impairment is ignored. Not to mention they can injure themselves. And as a best practice, even though the FMCSA only requires a new supervisor to undergo this training only once, I really recommend doing refresher courses every couple of years as substance trends change and supervisors need to stay sharp. Okay, so here's something for you to think about. How many of your supervisors who've completed, how many of them have completed the supervisor training more than 5 years ago? If you have any that have completed the training a long time ago, do you really think they're going to remember how to properly deal with the reasonable suspicion situation? If they're not staying on top of and staying current with what the various reasonable suspicion scenarios could be, they're going to have a hard time deciphering what is required when looking into those specific situations. Now, it's crucial that we understand the frequency and timing of DOT regulated drug and alcohol tests. DOT testing isn't a one and done event, okay? It's a continuous process that touches every stage of employment for safety sensitive positions. So I'm going to break down the main types of DOT testing. So first and foremost is the pre-employment test. So anyone can start DOT regulated, sorry, before anyone can start DOT regulated duties, they have to actually pass a DOT drug test or controlled substances test. And this is a gatekeeper step, okay? There aren't any exceptions. And it sets the standard for a drug-free workplace from day one. And just a side note on that, alcohol testing, it's not technically a requirement under the rules, under the DOT rules. However, an employer can choose to conduct alcohol testing for pre-employment purposes, so long as they do that for all of their pre-employment tests and they ensure it's communicated properly to their staff through their drug and alcohol policy. Next, we have random testing. Okay, so this is an ongoing requirement and it's based on the DOT's annual selection rates. And more specifically, the FMCSA's random testing selection rates for 2026 for this year are set at least 50% of your average driving workforce for drugs and 10% of your workforce for alcohol. And so what that means is if you had an average of 100 regulated drivers in 2026, you're going to be sending approximately 50 of them or more for drug testing and 10 or more of them for alcohol testing. And random tests have to be spread throughout the year, evenly throughout the year, and they must be truly random, okay? There shouldn't be any large grouping of random tests all at the end of the calendar year just to get it done, okay? DOT auditors look for patterns, and clustering tests into 1 month in the calendar just to get it done isn't going to cut it. DOT auditors are going to pick up on that. And I'm going to revisit random testing in another slide, okay? But moving along, the next testing reason is post-accident testing. And under FMCSA rules, after there's been a qualifying accident, such as a crash involving a fatality, the driver has to be tested. And this testing helps determine if substance use played any role in the accident and protects both the company and public safety. Then we have what's called reasonable suspicion testing. And this is where that supervisor training I spoke of uh, comes into play. Supervisors who've completed the DOT required training can order reasonable suspicion training if they observe the signs of impairment for one of their drivers, such as slurred speech, erratic behavior, or the smell of alcohol. And reasonable suspicion testing is a critical safeguard for maintaining an accident-free workplace. And the last testing reason, actually, there's two of them. The last two testing reasons are return to duty and follow-up testing, which are connected to each other. So after a drug or alcohol violation, a driver has to complete the return to duty process by meeting with a substance abuse professional and then passing a return to duty test. And then assuming the driver completes those necessary steps, they're then subject to a minimum of 6 unannounced follow-up tests over the course of the next 12 months. And I'm going to revisit that return to duty process in another slide just so I can explain it a bit more. Now that sums up the different DOT tests and how often they are conducted. And just a quick note, DriverCheck is here to help educate you about testing and help you use scientifically valid random selection processes. Now, continuing on that theme of, what does it mean to be DOT compliant? Well, when we talk about being DOT compliant, I'm referring to strict adherence to the U.S. federal regulations, specifically Title 49 CFR Part 40 and Part 382 of the U.S. Federal Code of Regulations. And these are the DOT and the FMCSA's specific testing regulations. So what I'm not talking about here are any of the other DOT regulations. Okay, the DOT regulations cover a whole host of different requirements such as vehicle safety and insurance, driver's hours of service, even driver licensing. I'm not getting into that. I'm strictly focusing on drug and alcohol testing compliance. But what does that look like in practice? Okay, what does compliance look like? Well, it means using certified laboratories and collectors, as that's going to ensure accuracy and reliability of testing. Compliance also means using proper testing procedures. Every step from specimen collection to reporting has to follow DOT protocols. And even small deviations like using non-DOT forms can trigger audits and penalties. And a strong and robust collection site network that uses tried and true collection procedures and certified collectors can help fulfill this compliance need. And compliance means you also using a licensed physician who's been certified as a medical review officer for DOT drug testing purposes. Compliance also means doing all of the testing I described earlier when it's required to be done, such as testing new drivers and then testing those same drivers throughout the year for random purposes, for random testing purposes. And compliance means accurate record keeping. Okay, documentation is everything. If it's not documented, the DOT doesn't consider it done. This includes test results, random selection lists, supervisor training records, as well as the clearinghouse queries. And speaking of the clearinghouse, that's also key to DOT compliance. You have to report violations into the clearinghouse and conduct necessary searches, also known as a query, of driver's records. And any violations, such as a positive test or refusal to test or perhaps a failure, those have to be completed and reported promptly. And I'm going to speak a bit more about the clearinghouse in another slide. But just to reiterate my previous point, I'm focusing solely on drug and alcohol testing, not any other area of DOT regulations. Okay. Compliance really does have real world consequences. I've seen companies use generic forms for DOT testing, like they're using non-DOT forms, thinking, the form's close enough. Well, that in itself can be a violation. So even minor paperwork errors can lead to an audit or maybe even a fine, depending how egregious the error is. And as a best practice, you should conduct regular compliance audits on your testing program. And I encourage you to treat compliance as an ongoing process, not a one-time checklist. And you should be asking yourself, is my drug and alcohol testing program DOT compliant? So now we're going to focus on the FMCSA Clearinghouse. So one question we get a lot at DriverCheck is whether the clearinghouse is actually mandatory. And the short answer is yes. So the DOT, or I really should say the FMCSA Clearinghouse, is absolutely mandatory. And this is one of the most critical compliance requirements for employers and drivers today. So let's break down what this means and why it matters. So the Clearinghouse is an online database managed by the FMCSA, and it was introduced to close a dangerous loophole that previously existed in the trucking industry. So before the Clearinghouse, drivers who tested positive or refused to test could simply move to another employer without disclosing their violation. And this created a serious safety risk because employers had no centralized way to verify a driver's compliance history. Like they could ask the driver, do you have a violation history? But if the driver lied to them and they aren't, that employer's not able to follow up with the previous employer and get a definitive answer, that new employer was kind of stuck with that situation. And what the clearinghouse does is it really removes that loophole. Okay, it gives a centralized database. You can go look at it and see, okay, is there actually an existing record for this particular individual that I'm going to hire? And it ensures that drug and alcohol violations follow the driver, making it near impossible to hide noncompliance from a DOT perspective. And the clearinghouse isn't about just closing loopholes that existed, but it's also about increasing compliance with the regulations themselves. So, who needs to register for the clearinghouse? Well, for starters, registration in the clearinghouse isn't just for drivers, it's required for multiple parties involved in the compliance process. So let's break it down into who has to register and why. So first off is employers. Employers need to register, and this is for regulated employers. Keep that in mind. So regulated employers must register in the clearinghouse, and they must do so in order to do some of the following. So employers have to be able to report violations, such as, driver refusing to test, or perhaps a driver blew over the limit on an alcohol test. They've also got to do, they have to run pre-employment searches, or what's called a query anytime they hire a new driver and before putting that driver behind the wheel of a commercial vehicle. Employers also have to run annual queries on all of their drivers, as that helps maintain an overview of all the drivers who may be working for multiple employers. You have some drivers that work for 2, 3, maybe even 4 different trucking companies. You also have to, as an employer, you also have to pay for queries. The clearinghouse isn't free. There's a $1.25 charge for each query that's run, and that's payment to the FMCSA. Employers also have to enter any successful completion of return to duty testing into the clearinghouse. And last but not least, if an employer chooses to use a third-party administrator, such as DriverCheck, to help run their clearinghouse compliance, that employer actually has to go into the clearinghouse to then assign that specific administrator to run their program. So you can't just automatically assume, okay, DriverCheck's got it. They're going to take care of it. You actually have to make assignments within the clearinghouse. Second for registration are drivers. So all cross-border commercial drivers that are regulated by the FMCSA should be registering in the clearinghouse so they can perform actions such as consenting to employer queries, as well as reviewing their own records. And if a driver refuses to register, it's probably not a great situation, because they're not going to be able to consent to a possible query if a situation arises where that particular driver has a record in the clearinghouse. Okay. Third, but not least for registration, are what's called service agents. And service agents include various parties, such as the medical review officers, or what we call MROs. They also include substance abuse professionals and third-party administrators, such as DriverCheck. And, MROs, they have to be going into the clearinghouse to enter drug testing violations. Substance abuse professionals need to be in there so that they can provide return to duty services to a particular driver following a violation. And then for third-party administrators, they help with managing queries, like actually conducting queries and reporting violations on behalf of an employer, something like, refuses to test, or an alcohol violation. And just a word to the wise on this. Failing to use the clearinghouse is considered major violation. So if you hire drivers without running a query, like without running a pre-employment query in the clearinghouse, and that particular driver has an unresolved violation, and they'll typically have a status in the clearinghouse saying driver prohibited, like the company, is going to be held liable for any accidents or incidents that occur while they operate a DOT regulated vehicle. And the DOT can impose fines, revoke operating authority, and even pursue criminal charges in severe cases. So here's an example. So a carrier hires a driver without checking the clearinghouse, and that driver has a prior violation and a prohibited status in the clearinghouse. And then that driver causes a serious accident. Well, during investigation, the DOT discovers that compliance failure. that particular carrier can now face thousands of dollars in fines. They could potentially lose major contracts, depending how much word gets out about this situation. And that really could have devastating consequences, especially on smaller companies. And it might even put you out of business, depending what kind of situation your business is, what situation your business is in financially. And so, as a best practice, you need to make sure that the clearinghouse is part of your hiring practices. And, you can assign, a compliance officer or safety manager to oversee your clearinghouse tasks. But I highly recommend you work with a third-party administrator like DriverCheck to help you manage the program on your behalf. That way, you're doing things that need to be done. Uh, and you can think of the clearinghouse as a compliance safety net, okay? What the clearinghouse does is helps protect your company from hiring DOT drivers that pose a risk. And ignoring the clearinghouse is like driving without brakes, in my opinion. You're going to head for disaster. So I'm going to shift gears uh, just a bit and take a deeper dive into DOT random testing because this is one of the most scrutinized aspects of DOT compliance and one where even well-intentioned companies can slip up. So first are the numbers. The FMCSA mandate, like I said earlier, mandates that at least 50% of your drivers, your regulated drivers, go for drug testing, and at least 10% of your drivers go for alcohol testing. And these percentages aren't suggestions. They are US federal requirements. So, for example, like I said earlier, if you have 100 drivers, like an average of 100 drivers over the course of a year, you're going to have to test 50 of them for drugs and 10 for alcohol throughout the year. But hitting these percentages isn't um, isn't the only thing that you have to be worried about, okay? So why random testing works and why it's done is because random testing is unpredictable. So drivers know that they can be selected at any time, which acts as a powerful deterrent against substance use. So if employees, drivers know that all tests are going to happen just in the month of December, they're going to adjust their behavior accordingly. And that's going to defeat the purpose of random testing. And the DOT expects you to spread all your random testing evenly throughout the year across all months, days of the week. Okay, and DOT auditors look for patterns. They will look for clustering to see if all tests are done just strictly, let's say on a Monday. That's your day. You like picking Monday for random testing, or you like just doing random testing in the month of September because everybody's back to school and your drivers are all back from vacation. The DOT is going to flag that as an issue because it's not truly random. You're kind of forecasting to your driving workforce that, hey, we're only doing drug testing, random drug testing in this specific time period of the year. And that's going to fall flat with the DOT. So the other key here is the random selection process itself has to be scientifically valid. So manual methods like pulling names from a hat or letting a supervisor choose who they want to go for testing, that doesn't meet DOT standards for being scientifically valid. And quite honestly, it's not random either, especially if you're just letting a supervisor random, pick on a whim. That's going to fail. And that's why third-party administrators like DriverCheck use automated computing systems to ensure selections are truly random and compliant. So here's a real-world example. So a freight hauling company, they meet 50% drug testing rate, but all their tests are done in the month of December. The DOT is going to flag that as a violation, issue penalties, and require the company to overhaul its process. And so what's the lesson learned there? Well, meeting the percentage isn't enough. Timing and randomness matter just as much. So what I'd like to ask you is, how do you currently manage random selections? Is your process manual? Is it automated? Is it scientifically valid? And what challenges have you faced in spreading tests throughout the year? Right, just something to ponder. So now I'm going to clarify two often misunderstood areas of DOT compliance, and that's the substance abuse professional, or what we call a SAP, and the return to duty process, or RTD process. And these aren't just regulatory requirements, okay? They are essential safety or safeguards for public safety and employer liability. So first, we'll focus on the SAP's role and then the RTD process. So the SAP is a DOT qualified professional whose responsibility goes far beyond simply approving a driver's return to work. So when a driver violates a drug or alcohol rule, whether by testing positive or refusing to test, they are to be immediately removed from DOT safety sensitive duties. That driver then has to undergo an evaluation by a substance abuse professional, by the SAP. And it's the SAP's job to assess a driver from a substance abuse standpoint and then recommend a tailored course of treatment or education. And this can range from, simple educational reading material to counseling or even to formal rehabilitation, depending on the SAP's assessment of that driver's specific condition. And then only after the driver completes the assigned treatment or education, that's when the SAP can then conduct a follow-up evaluation and issue a written report to the driver and to their employer outlining what the next steps should be. And importantly, drivers can't just wait out a suspension or simply retest to return to work, okay? So every step of the substance abuse process has to be followed. Skipping any part is a DOT violation, and it exposes the employer to penalties and fines and even increased liability, especially if an accident occurs for a specific driver. Now, our next focus is on the RTD process. So the RTD process is closely linked to the substance abuse professional, and it's equally critical. So many employers mistakenly believe, a negative drug test or alcohol test is all that's required for a driver to return to DOT work. But in reality, the RTD process involves several mandatory and documented steps. So as stated a minute ago, after drug and alcohol violation, the driver needs to be removed from safety-sensitive duties. And then from there, the driver has to register in the FMCSA Clearinghouse if they haven't already done so. And the employer provides a list to the driver of all the qualified substance abuse professionals that the driver can then reach out to and contact. Once that driver's made the decision on which SAP they want to work with, they'll need to then assign that particular SAP within the Clearinghouse web portal. And then the SAP will then either accept or reject the driver's assignment. And assuming the SAP accepts the assignment, the driver will then meet with the SAP for an initial assessment, and that will help determine what sort of treatment or education is needed in terms of their substance use. And the SAP will then go into the clearinghouse account and indicate the driver has had their initial assessment. Then next, the driver will complete the treatment and or education the SAP has provided them. The SAP then conducts a follow-up evaluation on the driver to determine fitness for safety-sensitive duties. And once this is done, the SAP will go into the clearinghouse and update the driver's status to say the driver is now eligible for return to duty. From here, I know this is long. From here, the employer will then send the driver for a return to duty drug and or alcohol test. And the driver must pass that return to duty test before being allowed to drive for DOT purposes. And assuming the driver does pass this test, the employer or their third-party administrator will then need to go into the clearinghouse and enter the negative test result. And upon returning to DOT duties, the process isn't done, okay? The driver will then be subject to unannounced follow-up testing, and at least 6 follow-up tests must take place in the first 12 months of returning to duty according to the regulations. But sometimes it can be longer, and sometimes there can actually be more follow-up testing than the minimums of 6. And that's all based on the SAP's recommendations. Now, skipping any step in this process that I just described can lead to penalties for the employer and the driver, depending on the situation. So here's an example of for you. Let's say you terminated a driver for a positive drug test, but then you subsequently rehired them. That driver gets a negative result. or on a return to duty test, but without going to see a substance abuse professional or without receiving treatment. Now there's no status update in the clearinghouse. They're still listed as driver prohibited. That driver's on the road driving somewhere in the US. They get pulled over and they get inspected by the DOT. Well, that during that inspection, it comes to light that the driver's in a prohibited status within the clearinghouse. The DOT can give that particular driver an immediate roadside suspension, and now your commercial load, your vehicle, your truck is stuck on the side of the road in the US, and you're having to send a spare driver down to go pick up that load. It's not a good spot to be in. Okay. So, as a best practice, not only should you follow every step of the return to duty process, but you should also document every step in the process and ensure the clearinghouse is up to date. Okay, so keep in mind, here's something crucial too. Keep in mind, the FMCSA and the DOT have access to the clearinghouse, and they can check any driver that's in there and any employer and see what exactly is going on. They can look up your company and see, okay, are you doing your queries? Are any of your drivers in a prohibited status? They can check all of that. So I'm going to shift gears again. So what does DOT drug testing test for? And that's a really good question, as the answer to it determines what substances would be identified by a laboratory and could potentially impact your drivers undergoing testing. So first off, drug testing for DOT purposes must either be urine-based or oral fluid, and in both cases, the testing has to be laboratory-based, meaning an instant on-site test result isn't going to count. And just a quick note on oral fluid. So while it's technically allowed under the regulations right now, no one can actually do it. Okay, oral fluid for DOT purposes can't be done yet because 2 laboratories have yet to be certified for DOT purposes to actually conduct oral fluid testing. So even though it's technically allowed under the regs, no one can actually do it. Now, that being said, the DOT tests for what's called a standard 5-panel. And the 5-panel tests for the following 5 categories of drugs. So number 1, you have marijuana or THC. Number 2 is cocaine. The third is amphetamines, including methamphetamines. 4 is opioids, including heroin and certain semi-synthetic opioids like oxycodone and hydrocodone. And the number 5 is phencyclidine or PCP. And these substances were selected to be part of the DOT's regulations because they pose the highest risk for impairment in accidents and safety-sensitive roles, such as driving. And the DOT's focus is on preventing catastrophic accidents caused by substance use. And then this 5-panel test is periodically updated to reflect emerging trends. Now, speaking of new trends, and this is the one for those of you who've been around the block a few times, this is the new information. So here's what's been happening recently. So in September of 2025, so just a few months ago, the DOT proposed adding fentanyl and norfentanyl, which is a metabolite of fentanyl, to their drug testing panel. So that panel I just spoke about, they're wanting to or planning to add fentanyl to that panel. And according to the DOT, adding fentanyl to its drug testing panel is in the interest of transportation safety, given compelling information regarding the number of overdose deaths involving fentanyl. And just a quick note on that, while the DOT has proposed adding fentanyl to its testing panel, as of today, as of March 2026, the regulations don't actually include fentanyl just yet. So until such time that the DOT officially adds fentanyl to its testing panel, it won't be tested for DOT purposes. So I just want you to be aware of that. It's not currently in there yet, but it is in the pipeline and the DOT is actively considering it. Now, the other drug that's being talked about quite a bit is marijuana. So you might have heard that in December, this past December, U.S. President Trump signed an executive order directing U.S. federal authorities to reschedule marijuana from a Schedule 1 substance to a less restrictive Schedule 3 controlled substance. And this is a significant shift in longstanding U.S. federal drug policy. But what I need you to understand is that this doesn't currently affect and doesn't change the current DOT testing panel. So what the rescheduling does is it aims to acknowledge marijuana's medical uses and reduce some regulatory barriers that exist within the US, particularly among medical research and potential tax and banking access for cannabis-related businesses, because there are a number of US states that have uh, legalized for recreational purposes. They've legalized marijuana at the state level, but they're having problems using banking because that's regulated at the federal level. I'm not going to get into the law there. I'm not an expert in banking regulations for the US, but there's a clash of differing governing laws there in the US that they're trying to overcome by reclassifying and rescheduling marijuana. But what this might mean for DOT regulated employers is that it does not fundamentally change US workplace drug testing obligations at this time, okay? You should still rely on existing regulations and keep testing in accordance with the DOT requirements. And DriverCheck's going to continue monitoring guidance from US regulators on how changes to US laws and regulations may influence future testing protocols. Now let's focus on alcohol testing. So under DOT regulations, alcohol testing is just as critical as drug testing, and the rules are very specific. The DOT requires a breath or saliva test to measure alcohol concentration for safety-sensitive employees. And the prohibited alcohol concentration is 0.04 or higher. If a driver tests at or above this level, they must be immediately removed from duty, and it's considered a violation under the regulations. But there is an important nuance. So under the regulations, if a driver's alcohol concentration is between 0.02 and 0.039, they must still be removed from safety-sensitive duties for 24 hours, even though it's not considered a reportable violation to the clearinghouse. And that's a common compliance pitfall. So some employers think that an alcohol concentration of 0.02 is acceptable, but the DOT rule requires that drivers removed for 24 hours. So as an example, if a driver has an alcohol concentration of 0.03 during a random alcohol test, they can't return to driving duties for 24 hours. And quite honestly, you don't want a driver who's intoxicated, even only mildly, to be driving one of your vehicles, as it's a safety risk, a financial risk, and even a reputational risk. Immediate removal is non-negotiable. And as best practice, you should have clear written policies for alcohol use and educate your drivers regularly. So what are the consequences of non-compliance with the DOT regulations? Well, when we talk about DOT compliance, it's easy to think of it as just paperwork or administrative tasks. But let me be clear. Non-compliance is not just a regulatory issue, it's a serious business risk that can have devastating consequences, okay? So let's break it down into three major areas. There's financial penalties, operational impact, and reputational damage. So regarding financial penalties, the DOT and FMCSA take violations very seriously, and fines can range from hundreds of dollars to tens of thousands of dollars per violation. So, let's say you failed to implement a random testing program, that can result in a fine of up to $10,000 per occurrence. And keep in mind, that's US dollars, okay? And right now, that's going to cost you a lot more if you're having to convert from Canadian dollars. So imagine if you have multiple drivers and multiple missed tests, those fines, those penalties are going to add up quickly depending which auditor is overseeing your testing program. As for operational impact, non-compliance can lead to suspension or loss of your DOT operating authority. And that means your trucks, your buses, your limos, they stop moving. Your contracts, they can be disrupted as well, and your revenue streams can dry up. And for many carriers, even a temporary suspension of their operating authority can be catastrophic. And you might even lose key clients who depend on timely deliveries. And rebuilding trust after a compliance failure is very difficult. Then there's reputational damage, okay? So in today's world, news travels fast. If your company is cited for non-compliance by the DOT and it gets out there, it's going to be in public records, industry bulletins, all over social media, and clients and partners may question your commitment to safety, and drivers might even hesitate to work for you. And we all know how hard it is to find qualified drivers these days. And as a best practice, you should conduct regular internal audits to identify gaps before the DOT does. And you should train your staff on the importance of DOT compliance, not just the rules, but the reasons behind them. So I'm going to look at employer responsibilities now. So employers such as yourself play a central role in DOT compliance. And it's not enough to say we have a drug and alcohol testing program. You need to actively manage and enforce it. So let's go through some of those responsibilities. So number one responsibility of an employer, DOT regulated employer, is to actually implement a DOT compliant testing program. And this means having policies that align with the regulations. It also means using certified labs and collectors, using a licensed MRO, and doing all that testing I talked about earlier, like pre-employment and random testing. Another employer responsibility is maintaining accurate records. The DOT requires meticulous record keeping. You got to keep records of all your tests, your supervisor training, your selection lists, and clearinghouse queries. And as previously mentioned, training your supervisors is definitely a responsibility. Supervisors have to complete that training on recognizing the signs of drug and alcohol misuse. Employers also have to report violations and return to duty testing into the clearinghouse. That's non-negotiable. If a driver tests positive or refuses to test, you have to report it promptly into the clearinghouse, and failing to do so can result in fines. You also have to ensure you have drug and alcohol testing policy in place as well. You need to make sure each of your regulated drivers review that policy and acknowledge it. And you have to make sure your drivers know what is and isn't allowed in terms of substance use. Right? Now, I focused on what employers have to do, but there's also responsibilities on the employee. So I've been focusing a lot on the employer, but the employee, the drivers have to understand the DOT rules as well, and they have to follow them. So, as I previously stated, drivers have to create or should be creating an account in the FMCSA Clearinghouse. That way they can consent to queries and also look at their own records and what it says. For all they know, there could be an erroneous, like a record that's wrong in there and that they have to dispute, because there are people similar names in the clearinghouse that where there can be overlap of records. If a driver tests positive or refuses to test, they can't return to DOT driving duties until they complete the SAP process and pass the return to duty test. Employees also have to read and acknowledge their employer's drug and alcohol policy and abide by it. Drivers should also speak with their physician and let them know of all their current medications and ask their physician if they have any safety concerns given their driving responsibilities. And as a best practice, you should educate your drivers about their responsibilities during onboarding and through regular training. And so today, we wanted to focus on educating the audience, on educating you about everything DOT, as education is very important to DriverCheck. But I'd be remiss if I didn't give a small sales pitch about DriverCheck and how we can help those that need to comply with DOT regulations. So you should choose DriverCheck because we combine expertise, technology, and personalized support to make compliance simple and stress-free. And here's what sets us apart, okay? We have a nationwide testing network. We have fast and accurate results. We have dedicated compliance specialists. We have automated reporting and tracking. We provide DOT compliant drug and alcohol testing. We offer supervisor training programs. We offer FMCSA Clearinghouse reporting assistance. And last but not least, we provide support 24 hours a day, 7 days a week. And compliance issues don't wait for business hours. Our team is available around the clock to assist you with your urgent needs. And so I ask that you choose DriverCheck in helping you with your end-to-end compliance management to help you save time and reduce your risk.